Hello everyone. The topic we will discuss in this lecture is from Jurisprudence, and the name of the topic is Theories of Negligence. Theories of Negligence. So, some writers they assert that negligence is a state of mind, while others consider it as a type of conduct. These two divergent views have given rise to two rival theories of negligence, namely, number one, subjective theory of negligence, and number two, objective theory of negligence. Now, let us first of all discuss subjective theory of negligence. What is subjective theory of negligence? So, the exponents of the subjective theory, they maintain that negligence is a state of mind. Negligence is a state of mind. According to them, negligence consists in the mental attitude of undue indifference with respect to one's conduct and its consequence. Now, Salmond, he supports this particular theory, that is subjective theory of negligence. Now, the exponents of the subjective theory of negligence, they maintain that negligence is a state of mind. So, we can say there is a mental attitude of negligence according to subjective theory of negligence, and this mental attitude is having the conduct and also having the consequence, and this was supported by Salmond, as we have discussed. So think about this for a while. Suppose a person is having the duty to allot 500 rupees to 30 persons, let's say to 30 persons in a village locality. So here the legal duty of the person is to allot the money to 30 persons in a village locality, let's say within a prescribed date. But suppose due to negligence that person did not do his duty and exceeded the prescribed date. So here the mental attitude of the person is being negligent to perform the prescribed duty. And what is the conduct here in this example? Not doing the legal duty. And what will be the consequence? 30 persons of the locality got deprived from receiving the money. This is the consequence. So here negligence is a state of mind in the subjective theory of negligence. Now, according to Austin, want of advertence, which one's duty would naturally suggest, is the fundamental idea in the conception of negligence. I am repeating this again. According to Austin, want of advertence, which one's duty would naturally suggest, is the fundamental idea in the conception of negligence. So, in this opinion, a negligent wrongdoer is one who does not know that his act is wrongful, but would have known it had it not been because of his indolence and inadvertence. Thoughtlessness is thus the essence of negligence for Austin. Thoughtlessness is thus the essence of negligence for Austin. Now, Austin goes a step further in elaborating the subjective theory and distinguishes negligence from heedlessness, rashness, and recklessness. For him, negligence is the state of mind of the person who inadvertently omits an act and breaks a positive duty. In heedlessness, He does not think of probable mischief and does not bother to avert the possible consequences. And in rashness, he does foresee the consequences, but foolishly thinks that they would not follow as a result of his act. Now, if we simplify this, okay, according to Austin, that is, the want of advertence, which one's duty would naturally suggest, is the fundamental idea in the conception of negligence. So, as Austin here is talking about a mental attitude. From the perspective of it, let us cite one example to make it clear. So, according to Austin, negligence is different from heedlessness. Heedlessness means unthinking. Okay. So, according to Austin, negligence is different from heedlessness, rashness, and recklessness. Negligence is different from heedlessness, rashness, and recklessness. And according to him, that is Austin, negligence is the state of mind of the person who inadvertently omits an act and breaks a positive duty. Let's say A is having the duty to keep a water reservoir clean so that the nearby industrial waste may not be able to pollute the water reservoir. Now here A's duty was, the duty of A was, let's say, to do the proper treatment of the water for the fishing purpose. But suppose due to his negligence, the water has become polluted. Now here, as far as this particular example that we have cited, it is concerned, some questions we may ask here. The first question is whether the negligence committed by A is a state of mind. What will be the answer? Of course it is a state of mind. Maybe A was, let's say, A was unmindful for other serious reasons, let's say related to his life, or maybe indolence, that is laziness. Maybe it may be one of the causes for this negligence. And the second question is that we can ask whether the duty to be performed by A has been inadvertently omitted. Inadvertently means unintentional or something which is unplanned. Okay. The second question is whether the duty to be performed by A has been inadvertently omitted. So the answer will be, from the perspective of subjective theory of negligence, the answer will be yes, because A committed this particular negligence not intentionally or not by pre-planning. It was his mental state and his omission or non-performance of the duty. It was totally unplanned. Due to this, he has broken his positive duty, and there was no motive behind this. This is very important. There was no motive behind this. It may be an outcome of laziness or indolence, which is again a mental state. Indolence or laziness. The third question which we can ask here is that whether A's act in this example was heedlessness, rashness, and recklessness. So, as per Austin's philosophy on negligence, it will not be treated as a case of heedlessness or showing a reckless lack of care or attention. You may ask this question, why? Because this mental state of A here in this example is not done to create a mischief or harm. It was not done to cause harm to others, and as such he was not aware of the consequences because it was not done with a pre-planned ill intention. In rashness, what happens? The person foresee the consequences but foolishly thinks that they would not follow as a result of his act. Here, what happened? A inadvertently or in an unintentional way omitted, or we can say did not perform his duty. So A's conduct in this example is not having relation with rashness, is not having relation with rashness. Now, recklessness, on the other hand, is a condition of mind where the doer foresees the consequences but does not care whether they result from his act or not. Thus, the line of distinction between rashness and recklessness is very thin. In the former, there is erroneous thinking that consequences would not follow, while in the latter, the person does not bother about the consequences at all. Okay, so here is negligent. That is, in this example, is negligent, or the negligence committed by A, or negligent conduct of A was unintentional. The negligent conduct of A, it was unintentional, or we can say unplanned in this example. There is no question of doing harm to others despite the consequences. A's mental state here in this example was more or less an outcome of indolence, or we can say laziness. Okay. Now Salmond objects to this subclassification of negligence made by Austin, and treats all these categories under the common head, namely negligence. The reason being that in all of them there is failure to exhibit the standard of care required of a reasonable man. Okay. So in his opinion, Austin's view is fallacious, because negligence may also be deliberate or willful. He therefore concludes that the essence of negligence is not inadvertence but carelessness, which may or may not result in inadvertence. Okay, I am repeating this again. He therefore concludes that the essence of negligence is not inadvertence but carelessness, which may or may not result in inadvertence. So the main essence of Salmond's definition of negligence is the outcome of carelessness. Okay, this is the essence of Salmond's definition of negligence, that it is the outcome of carelessness. So when there is no standard of care, when there is no standard of care required to be taken by a reasonable man, there is negligence, and there is no subclassification of negligence according to Salmond. Now it may be a result of inadvertence, that is, it may be unintentional, or it may be pre-planned, or intentional by omission, or by not doing, or by not doing the duty. But here the important thing to be considered in negligence is that whether there is a failure to exhibit the standard of care according to Salmond. Now in subjective theory, the mental state has been given importance when it comes to negligence. That is why the term subjective has been used. The term subjective, it has been used. Now let us come to this objective theory of negligence. Objective theory of negligence. Now according to this theory, that is objective theory of negligence, negligence is not a condition of mind, but a particular kind of conduct which is to be judged objectively. So objectively, objective theory of negligence. Okay. So this theory is supported by Federick Pollock. Federick Pollock, he defines negligence as the breach of duty to take care, which a reasonable person under those circumstances would take. The tort of negligence is based on objective approach to the conduct and its consequences. So if you simplify it, so in subjective theory of negligence, the mental state has been given importance, the mental state. But when it comes to objective theory of negligence, conduct has been given importance in the objective theory of negligence. Negligence is a particular type of conduct according to objective theory of negligence, which is judged objectively, not subjectively, according to this theory, that is objective theory of negligence. Now, according to Federick Pollock, he defines negligence as the breach of duty to take care which a reasonable person under those circumstances would take. So it is based on objective approach to the conduct and its consequences. So if we can recall the example of that reckless driving through a crowd, we will see it is not something a reasonable man would do. A reasonable man would go slowly through the crowd so that no injuries are caused to others in the crowd. So here the mental state is not important, but whether the standard of care or reasonable care was there or not, or whether such reasonable care has been taken or not, these things will be taken into consideration in objective theory of negligence. So if a person negligently drive and go through a crowd, then it will be treated as a negligent conduct, as a negligent conduct. If a person negligently drive and go through a crowd, then it will be treated as a negligent conduct. And what might be the consequences here? Causing injury to others. So Dr. Winfield defines negligence as the breach of a legal duty to take care which results in damage undesired by the defendant to the plaintiff. Thus, the three essential ingredients of negligence as a tort are: number 1, existence of a legal duty; number 2, breach of the duty; and number 3, consequential damages. All these are to be judged objectively on the basis as to how a reasonable man would have acted in those circumstances. So if you simplify it, Dr. Winfield defines negligence as the breach of a legal duty to take care which results in damage which is undesired by the defendant to the plaintiff. So if a person go through a crowded place, let's say, or drives through a crowded place, what will be the legal duty of that person? The legal duty of that person would be to maintain reasonable care so that other persons won't get injured, to drive slowly and carefully. Okay. So if this legal duty is breached by reckless driving through a crowded place, what will be the consequence of it? Causing injuries to others, or even death. It may cause death. Who will go to the court of law for relief then? The aggrieved party or the plaintiff who is injured, and the person who did reckless driving will be the defendant. So the conduct here in this example is reckless driving. The conduct here, this is very important as far as this example is concerned. The conduct here in this example is reckless driving, which is negligence, or the conduct here itself is negligence, that is objectively. Okay. So thus that as we have discussed about the three essential ingredients of negligence as a tort. The first one was existence of a legal duty. The second one was breach of that duty, and the third one was consequential damages. Now let us discuss about this. Let us little bit discuss these three substantial points here. So here, as far as this particular example is concerned, so here the legal duty in this example is not to drive recklessly through a crowded place, which is a conduct, an objective. Okay. And number two, the breach of duty has been done by driving recklessly through the crowd, which also is a conduct and objective. And three, and the consequential damages are what? Are injury or death caused to the persons in the crowd, which is also a conduct or objective. Now, all this are to be judged objectively on the basis as to how a reasonable man would have acted in those circumstances. Okay. So, Salmond criticizes objective theory of negligence on the ground that it loses sight of the essential distinction between intention and negligence. For him, for Salmond, negligence is purely mental inadvertence and nothing more than carelessness. Okay. So, according to Salmond, negligence is purely the outcome of mental state, or we can say is purely mental inadvertence and nothing more than carelessness. Thank you.